Good morning, everyone. I'm Robert Appel. I'm an attorney with the law firm of Conrad, Bannon & Appel in Hinesburg, Vermont. With me today is my client, Rhonda Taylor, the mother of MacAdam Mason, who was killed 2 years ago on Friday after being shot with a taser by a state police trooper named David Schaefer. With us here today is her husband, Ken. I'm going to hide Ken. And Alan Gilbert, who most of you know from the Vermont chapter of the American Civil Liberties Union. I have to say this is a very sad day, not only for Rhonda and her family, but in my view for the state of Vermont. That this is the only way that the people of the state can hold police accountable, which is what our Constitution says. Chapter 1, Article 6 of the Vermont Constitution says that internal police officers shall be fully accountable to the people of the state. Unfortunately, left to their own devices, supervising law enforcement executives have not done well in holding police accountable when they break the law or break policy. As you all know, our Attorney General has a record of not bringing criminal charges against police when they engage in misconduct, including excessive use of force. The only exception to that is that Corporal Jason Noakes of the Winooski Police Department, as many of you know, was the subject of a grand jury indictment that was initiated by State's Attorney T.J. Donovan here and joined by the Attorney General's office. I have two of them involved in that case, representing Mr. Sage, who was shot by Corporal Noakes. Again, in my view, it's very important that police whose job it is to serve and protect all of us are held accountable to legal standards. So that is why I decided to become involved in this matter. It's been a very long, hard process for Rhonda and Kenny and their family. But here we are, about to go in and file this complaint. I think it's very important that these cases be brought forward so the people, not only the people harmed by these acts, can seek and achieve justice and remedy, but the broader people of the state know how our police work and when they fail to work in lawful ways. So with that, I'm going to turn it over to Rhonda if you have anything you want to say.
I just would like to thank you all for being here and for caring about my son and what happened to him, and nothing will bring him back. We live with that every day, but I'm hoping this will make a difference for others that have losses such as ours. I'm very proud we were able to work through the process of having a taser bill signed into law last week, and that feels like that was for my son. I know it was for many other people as well, and this was hard to come to this. This was a difficult decision to come to this point, but I feel that people need to be accountable for the death of my son, and thank you again.
Alan?
Yeah, the American Civil Liberties Union has had a long interest in police accountability, and actually police also have an interest in police accountability because it's often been said that the best weapon that police have in doing their jobs is public trust. And when there isn't the public trust in police, then police have a much harder time of doing their jobs effectively and efficiently. Vermont has not done a good job in giving the public access, in understanding why police sometimes do the things they do, and this actually works not only sometimes against citizens, but against the profession itself. And we think it's important that the public have more access to their investigations, the results of investigations, than is currently in place. So we think that this lawsuit is actually a natural outgrowth of the problem that Vermonters don't have the kind of access to public records involving police and police management that they need in order to judge whether police are doing the kinds of jobs we want them to do. So we're sorry that Rhonda Taylor is again being put on the spot. She's been a real advocate for trying to improve how police interact with folks. She's had personal experience, obviously, and she's trying to do something about that. And we really applaud the strength she's had in seeing these issues through. Thank you.
Here's a press release that you're welcome to have, and we'd be happy to take questions.
What does the lawsuit actually ask for?
The lawsuit asks for compensatory punitive damages for the harm that Mr. Mason suffered on the afternoon of his death, as well as what's known in legal terms of the loss of consortium by Ms. Taylor of her adult son, which is known to be recoverable under Vermont law.
How difficult is a case like this to win, given that the Attorney General has made a decision about that nothing improper occurred? And
Well, Sam, I'm sure you recall the famous case of O.J. Simpson. We have two systems of justice in our country. One is the criminal system, where a defendant must be proven beyond a reasonable doubt to have committed a crime. Beyond a reasonable doubt is a very weighty standard. It's a doubt based on reason, is close to certainty, relatively close to certainty. When judges instruct on that standard, they have the scales of justice, and they say for it to be beyond a reasonable doubt, the evidence in favor of conviction has to be way down here. In a civil matter, which this is, the plaintiff's burden, Ms. Taylor's burden, is to show by a preponderance, meaning more likely than not, that the elements of the causes of action that we're bringing were proven by the evidence produced at trial. So it's relatively routine that even when people are acquitted in a criminal case like O.J. Simpson, they're still found liable in civil suit because of the lesser standard of proof.
Yeah, but even given that, I mean, a lot of these civil cases are tough to prove. A lot never going to make it to trial. I mean, how are you going to overcome qualified immunity?
Well, we think that the way the complaint is phrased and framed is that we believe David Schaefer violated Mr. Mason's constitutional rights in the way that he was seized on that day by the excessive use of force by deploying his taser under circumstances where there were many other means to resolve that situation short of that application of significant force. In addition, by that point in time, the state police had adopted a policy based on a prior unfortunate situation that tasers were not to be used against people with disabilities. Mr. Mason was known to have disabilities since the report to the state police had come from Dartmouth Hitchcock after Mr. Mason had called the Claire Martin Center, his local community mental health agency, who referred him to Dartmouth, where he was treated by a neurologist for seizure disorder. So we believe the evidence will show that Mr. Mason had a significant disability, had a seizure on the day before his death, and that seizure caused him not to process information correctly, and according to his life partner, Teresa David Donis, it was not unusual for him to act inappropriately or hypersensitively and sort of be out of it the day after a seizure. I don't have seizures, but I have migraines, and I know that for a period of time after that, I'm not quite right. So, in our view, since the state police had this knowledge coming from a medical provider, they had a duty, consistent with their taser policy, not to use a taser on this individual. In addition, there's evidence that we've obtained from the state police that indicate that David Schaefer had been to a taser training, taser recertification in March of 2012, and signed a document issued by Taser International that warned against shooting persons with disabilities, persons with seizure disorder, and particularly shooting persons in the chest with the taser bar, which is exactly where Trooper Schaefer hit MacAdam Mason, who's on the left side of his chest near his heart. So the deputy chief medical examiner of the state of New Hampshire, where the autopsy was performed, found that Mr. Mason died from cardiac arrest induced by an electrical weapon discharge. So I think there's significant evidence in our favor. It's always challenging to prosecute police either criminally or civilly because they do have a very difficult job to do, and I think we all respect the challenges that they face. But they too are bounded by both professional and legal obligations not to exceed the reasonable use of force as determined by the circumstances. At the time that Schaefer discharged his weapon, he had a rifle trained on Mason. Mason had been on the ground. He got up, started walking towards Schaefer, and at that point, he had nothing in his hands. Schaefer said before he saw him and told him to get on the ground, he saw him stumbling and looked like he was in somewhat of a haze, which coincides with the report from the medical professional that he has a disability. There were two other troopers within 25 feet of him, and nonetheless he used his taser. We don't think that's a reasonable use of force under the circumstances at that point in time.
Has the state made any effort to settle this, to head it off by offering you a settlement before you filed suit?
Not to my knowledge. Ron?
You talked earlier when you were talking, is this a over-lease in Vermont? I mean, is this type of thing happen a lot?
Well, a lot is a hard thing to define. When it happens, anytime it happens, it's a problem. The concern is without a means of holding police accountable, without some citizen oversight, which we do not have in this state, other than a state police advisory commission that is not transparent, does not release information to the public. The only way to determine how often it happens is by litigation, which is unfortunate. You know, the whole notion of laws and enforcement is to deter misconduct. So I think in some ways we're doing the general public a service by bringing actions such as this forward. By and large, most police officers in the state are highly competent, highly trained, and do their job very professionally. Like in any profession, there are bell curves and people on either end of that bell curve. So I think it's incumbent on not only the law enforcement profession, but we as a state, as required by the Vermont Constitution, to hold internal police accountable.
The legislature did take this issue seriously.
Yes.
New law just enacted this month. What's your take on that law? Does it not go far enough, isn't it?
Like many laws, it's a compromise. Maybe Alan can speak more about that. He was more involved in the day-to-day. It's certainly a step forward. It's an acknowledgement that Taser is... Now, Taser International used to term their product a less than lethal weapon. Now they call it less lethal. But they put so many warnings on it, and as Alan will likely point out, the legislation as passed requires the police to adhere to Taser manufacturer warnings, which may not have been the intent of the legislature, but I think it does provide significant protection if that law is followed, because Taser, and you'll notice we did not bring an action against Taser in this case, Taser has been consistently building a shell around themselves in terms of being held liable for product liability. Increasingly, they're saying don't use it on A, B, C, and D, a person running, a person under the influence, elderly, infirm. So the law now says that police are to comply with those warnings. So that may be the most important component of the law. Alan, you want to add to that?
Yeah, I actually think that the including of a requirement that officers have to follow the manufacturer's recommendations was intended, very much intended, because when you think about it, the state does not want people working for it to be using any device outside of what the manufacturer says is how it should be used, because you open yourselves up to all kinds of liability that I'm sure the state doesn't want to take on. So I think the inclusion of you must meet manufacturer specifications in terms of use really was very much intended. The core problem here is something we've been working on at the ACLU for a long time, and again, it's police accountability. It's not just tasers, and the taser law that was passed and signed last week by the governor is a good law around tasers, but there's the larger problem of making sure that police are being managed effectively so that they can be as professional as they possibly can in carrying out the duties that we, the public, ask them to do. And until we have a system that's more accountable, until we have a review process where the public learns about what exactly happened in the situation and were the officers involved doing the right things? Do they need more training? Do we need to look at how certain devices are being used? That's really a public responsibility. So we see the filing of this lawsuit as much a responsibility of us as citizens as anything else.
What would be, if you do prevail in court, or what sort of damages are you seeking? Do you have any idea of what would be?
As the finder of fact, the judge, well, we've asked for a jury, so as the jury sees fit. The jurisdictional limit of the court's generally $75,000, so in the cover sheet I say in excess of $75,000. It's really, the value of a human life is very hard to calculate. The value of a relationship between a mother and a child is very hard to calculate. And I would defer to the wisdom of a collection of citizens of Vermont to determine an appropriate award should they find the defendants liable. Let me add one more thing regarding the Taser bill. There are certain provisions in the bill that carry the conversation forward. One, there's a study committee that's formed to examine the use of body cameras so that there would be a visual and audio record of such interactions that result in us being here today. There were actually body cameras on some of the officers on the scene June 20th, 2012. However, they were either inoperative or not operative. That's a problem in my view. A recording of interactions, no matter where it happens. I mean, corrections has used it for years to de-escalate inmate guard behaviors. It tends to keep people honest. I mean, if you all want to look at a film of what happened, it makes it pretty easy to judge. So I think that's an important step forward. There's also a study. The study group is also looking at testing the actual discharge of the Taser weapon. There's some concerns that, and there was some testimony before the Government Operations Committees in this session, that these Taser guns can be either hot, meaning they charge more amperage than they should, which are dangerous, or cold, meaning they're not effective in producing the anticipated response, which is a subject collapsing to the ground. Was there a third component in the study?
No, it was those two things.
Okay. So I don't think the conversation's over yet, and I think we all are appreciative of the time and the effort the legislature put into the issue, and we are happy with that as an initial step, and we're pleased the governor signed it.
Rhonda, one person who would benefit from this lawsuit is your grandchild. I wonder if you could tell us how that child is doing and what your hopes for the child are through the lawsuit.
I can tell you that my son loved his daughter Cassidy very much, and my son would want to know that she didn't need to worry about going to college. That's what I would like to be able to see her be able to do is go to college. My son won't be here to be able to do that for her. And she's a beautiful little girl, and she misses her dad. On his birthday this last year, they had a birthday cake, and they let balloons go up to the heavens, and it was pretty special.
So it's been 2 years. Why is now the right time to file the suit?
Well, the statute of limitations is about to run, which is the primary reason. We wanted it to be, we frankly didn't want it to get mixed up in the Taser bill conversation, and we wanted it to be filed in a timely fashion. We also think it's appropriate to be filed close to the anniversary of MacAdam Mason's death.
Have you guys settled what's going on in probate court? I mean, there was an issue there with who has the estate. Is that done with in Orange County?
No.
So do you even know for a fact that you're the ones who control this estate?
As of today, yes. I can explain. Let me explain, as Desi Arnaz would say. The mother of the grandchild, after Rhonda came forward and asked for and was appointed administratrix of the estate, decided that she wanted to speak for the estate. And the probate judge in Chelsea took about a year and eventually granted her request. I appealed that decision. He dismissed my appeal because of what he perceives to be a procedural irregularity. That's now on appeal to the judge in the civil division and is awaiting decision. I did check with the court earlier this week as to whether Rhonda Taylor is still the administratrix and still has authority to speak on behalf of the estate of MacAdam Mason, and the answer is yes.
There's already been another suit filed related to this incident by MacAdam's girlfriend,
Right, Teresa David.
Teresa David Honest. How is this different, and how do you expect this to play out in a different way? Maybe the same.
We're not getting into some legal technicalities. The claim brought by Miss David Donis involved both intentional infliction of emotional distress and negligent infliction of emotional distress. Because she was there when this happened, she was on scene, she saw it go down, it had a dramatic emotional impact. In order to bring such a claim, you have to be present. Obviously, Ms. Taylor wasn't present. Actually, in the complaint to be filed after we all depart, we do bring an intentional infliction of emotional distress claim against Trooper Schaefer for pointing first a rifle and Taser Mason, because obviously we put him in distress prior to his loss of consciousness. So her claims are different. Teresa and MacAdam Mason were never married. There's no common law marriage in Vermont, so she doesn't have standing to speak on behalf of the estate. She's not an heir. So the claims we're bringing on behalf of the estate, meaning that money will go to Mason's minor child, and a loss of consortium, meaning the relationship Rhonda had with her son. But most of the claims are brought on behalf of the estate, meaning any proceeds will go to the daughter.
Why state and not federal court? Or why federal and not state?
Well, the primary, our first count is a violation of federal Constitution, 4th Amendment, 14th Amendment, in that we believe that when the troopers, particularly Schaefer, seized Mason on that day, there was excessive use of force. I mean, he didn't have to deploy the Taser. We've talked about it. He didn't have to hit him in the chest, et cetera, et cetera. I mean, the result was foreseeable in my view. So, it's brought under the federal Constitution. We just thought a federal court would be a more appropriate forum.
And did you seek any kind of settlement with the state? I was trying to follow up on Wilson's question.
I have not. There was preceding counsel. I don't believe there were any settlement discussions between the estate and the state of Vermont. I have to turn to Ron again. I don't believe so.
We hadn't reached that point.
No.
Have you not ever approached them and say, how about we settle this without going to court?
No, we have not. In a large measure because we think this is a matter of public interest. I think, and David Don is settled, by the way, if you didn't know that. We think it's important that the people know what their officers are doing. We think there is benefit, even if it settles tomorrow, that you're all here, we're telling our story, there's a complaint on file that sets forth what we believe happened. I think all of that promotes a greater transparency and public accountability of law enforcement, which, like Alan, I've worked many years in a variety of positions to advance. So I think it's important that the matter get aired.
You don't by any chance have a copy of the complaint to share with us, do you?
I do. I have
Beyond
several.
the press release? Good. Thank you. That's fine.
Hungry hands. Thank you. Thanks for coming out.
Thank you. Appreciate it.
Perfect number. Nobody got that one on the record. Anything else we can provide you this morning?
Your last name?
Thanks again. And my contact information's on the press release if you have need to call. So thanks again for your interest in the matter.
I involved with the initial reporting on this, but for people who don't know and who are just hearing this very
My son was MacAdam Mason. My son was MacAdam Mason, and he was an artist. He had a very big heart, and he also was a musician. He loved to play his guitar.
T or T?
T. From his art and his music. He loved to work in the garden.
Thank you.
I don't understand how it went from for help. And he was sent for a wellness check.
Lots of immovable objects.
Didn't have a weapon. He had a seizure. Taser the day before, and I just feel he should have been protected. And I can't tell you how hard this is to lose your children.
You know, all sensitive stuff's in the back.
Lose your children. You know, I wish I had been there. If I had been there, I lived in New Hampshire, and I was teaching a class at the time. And if I'd been there, we tried to get between them. Thank you.
It's good to see you again.